Good morning, everyone, and welcome to today's session, a workshop on residential estates, where we'll be looking at ways and hows to promote pro-competitive rules and regulations. My name is Karabo Mutaung, and I will be your program director for this session. I just want to confirm that all my panelists are in the meeting. I think I see them. Thank you very much. So maybe just some quick house rules just before we start. All the cameras and mics for the attendees have been disabled, and they will remain so throughout the workshop. We will have a Q&A session towards the end of our program. And so we invite attendees to post their questions in the post box. In the chat function. We will not be taking questions verbally. So please do post all your questions in that chat function. And when you do so, please also indicate to whom the question is directed, so that we do make sure that the question is answered by the correct person. With that also, I think please just be mindful that scenarios and questions that are legal based may not necessarily be answered in this platform. However, the panelists will, to the best of their ability, answer all the questions that are posed to them. Without wasting any more time, I am going to invite Mrs. Khanyisa Qobo, who is the Divisional Manager of the Advocacy Division at the Competition Commission, to come in and give the opening remarks. Thanks, Khanyi.
Thank you. Good morning, ladies and gentlemen, and welcome to the Competition Commission's workshop on promoting pro-competitive rules and regulations in residential estates. I welcome the representatives from various stakeholders in the residential estates industry, especially the representatives from the South African Council for the Architectural Profession, that's SACAP, the Association of Residential Communities, ARC, and the Community Schemes Ombud Service, as CSOS, all of whom have representatives on our panel today. I would also like to extend a very warm welcome to all the participants, which include representatives from service providers who offer goods in estates, as well as residents of estates who may be here today, and of course, homeowners associations and body corporates. The purpose of today's workshop is to raise awareness about the importance of pro-competitive rules and regulations on the appointment of suppliers or service providers in residential estates. Today's workshop is aimed at educating the residential estate community on competition principles, and also to encourage stakeholders to review their current practices when they develop rules and regulations which may be anti-competitive. Further, through the workshop, the Commission encourages homeowner associations and body corporates to manage their service provider panels in a way that increases consumer choice, that promotes inclusion, especially of SMEs and historically disadvantaged individuals, and also to broaden competition generally. The workshop, of course, aims to also encourage a discourse about how the Competition Commission can work with other regulators in the residential estates industry to address some of these competition issues, which we will be discussing today. Just to give some context, over the last few years, the Commission has received and investigated numerous complaints from residents who live in residential estates, and also from service providers regarding the rules and regulations of residential estates, which restrict competition or are exclusionary. Some of the issues that come up from these complaints include, firstly, that homeowner associations or body corporates appoint service providers without undergoing competitive processes, and that there's no review review processes in place. So there's a lot of opaqueness in how service providers are appointed. Another complaint or common theme that arises from complaints, rather, I should say, is that homeowner associations or body corporates conclude long-term or evergreen exclusive agreements with these suppliers. Also, a third theme that comes through quite commonly in the complaints is that HOAs, homeowners association and body corporates establish offending rules and regulations that often lack objectivity as they are drafted with the assistance of or in consultation with the very service providers that they would have then exclusively appointed, who, as of course in this scenario, would have incentives to protect their commercial interests by preventing potential competitors from also operating in their estates, which thereby reduces competition. So these offending rules, sometimes that are co-drafted with the appointed provider, sometimes relate to leasing and rental arrangements within the estate. And the more common theme is on built environment services such as architecture and engineering. This conduct by homeowners associations and body corporates, it of course limits the choices of consumers who are homeowners residing in these estates, and also subjects them to higher prices, which are charged then by these suppliers. This conduct also results in the exclusion of other competitors, particularly SMEs and firms owned or companies owned by HDIs, from entering and participating in the market, which reduces competition as well. So the Commission's investigation of complaints filed against residential estates have revealed that certain estates, in particular HOAs and body corporates, are of the view that they are empowered to self-govern and regulate their practices as they wish. Some of the submissions we have received from residential estates when we investigate complaints indicate that there is a view or perspective that the Competition Commission does not have jurisdiction to regulate the practices, especially where these bodies are also regulated by other regulators. We would like to clarify today that the Competition Commission's mandate to regulate competition as per the Competition Act extends to the rules and regulations of residential estates. When homeowners, associations, or body corporates exercise their powers and fulfill their respective mandates, they must ensure that they do not engage in conduct that contravenes the provisions of the Competition Act. The Commission has, at this point, opted to engage with industry stakeholders through advocacy in order to address these issues and to promote competition. It must be noted, however, that the Commission retains its right to scope for enforcement action in this area and to exercise its prosecutorial discretionary powers under Section 49B of the Competition Act in relation to homeowner association and body corporates that are not willing to reform their practices. The Commission will not hesitate to prosecute those who engage in practices that contravene the Competition Act. HOAs and body corporates are therefore required to ensure that their rules and regulations do not infringe on any provisions of the Competition Act. In conclusion, I would like to talk about cooperation between regulators. We note that some of the complaints against these rules and regulations of HOAs and body corporates are regulated by other sector regulators, as I've already mentioned. It's therefore critical that the Competition Commission collaborates with these regulators in regulating the issues. For example, the growing number of competition issues in the architectural profession have called for greater cooperation between the Commission and SACAP to strengthen competition regulation in the sector. The MOU concluded between the Commission and SACAP empowers these two institutions to cooperate on various activities, including the investigation of complaints and promoting competition in the sector. Earlier this year, in the context of this MOU, the Competition Commission and SACAP issued a joint circular on the anti-competitive effects of rules and regulations in residential estates. The purpose of the circular was to promote competition or fair practices that will enable architects across the various categories of registration within the profession to compete and to participate in the market for architectural services for the benefit of consumers. In the same vein, then, the Commission will explore collaboration with other relevant key stakeholders in the industry, including those that are participating in this workshop today and others, in order to promote these pro-competitive rules and regulations. It's clear then, ladies and gentlemen, that these issues have our attention and will be an area of focus for the Commission this year and in the near future. As such, we encourage homeowner associations and body corporates to undertake reviews of their practices with the aim of aligning them with the principles that will be shared during this workshop. I think at that point, then I'll stop and hand over back to you, Garabo. Thank you.
Thank you very much, Khanyi, for that background and just for putting things into perspective. I'm sure our participants, you know, are interested, are hearing you and are taking notes, you know, of some of these issues that you have highlighted and that will be engaging more on throughout the workshop. Thank you very much. We will now be moving on to our next session, which will be a presentation by the Competition Commission. I am going to invite my colleagues, Betty and Fatani, to come on and to put the presentation up and take us through this presentation. It was very much a flow from I think the opening remarks that Khanyi has made, you know, in terms of identifying some of those competition principles, you know, that residential estate homeowners associations as well as body corporates should be looking towards, you know, when developing the rules and regulations for their residential estates. Betty, over to you.
Thanks, Garabo. I am just projecting the slides now. They should be loading in a second. Yep, I think we can all see the slides. If not, please do let me know.
We can see them. Thank you.
Okay, thanks everyone. Good morning again, colleagues. And as noted by Ms. Motaung, this section of the workshop will focus on the Commission's presentation, just highlighting and diving a bit deeper into some of the points that were made by Ms. Qobo in her opening remarks. So as noted earlier, the Commission has obviously investigated a number of complaints that have been filed against residential estates, specifically focusing on the rules and regulations that are adopted by homeowners associations and in some cases, body corporates. So in this section of the presentation, we'll consider the competition issues, but what we'll also do is that we'll consider some case studies that will shed more light on the relevant competition issues that we are talking about here. And thereafter, we'll just touch on some competition principles that the Commission is advocating for in promoting pro-competitive rules and regulations for residential estates. Just for sake of clarity and flow of the presentation, just note that when we use the term residential estate, especially in the context of the rules and regulation making context, we would be, you know, really referring to homeowners associations and body corporates. So I will then begin the presentation just diving deep into some of the competition issues that the Commission has identified. And here I'll focus primarily on 3 issues, and these are issues that Ms. Qobo highlighted in her opening remarks. So what the Commission has found in relation to the investigations that it has conducted when receiving complaints from homeowners as well as service providers, is that, for example, number one, residential estates appoint suppliers and service providers without following a competitive process, whether that competitive process is a tender process or an RFQ process. And obviously the concerns here is that, when you do follow a competitive process, you allow for more suppliers and service providers to bid for the work, and they'd be able to compete on price. And that also means that then the best suppliers or service providers are then selected, and consumers benefit from the quality of goods and prices that are offered by those service providers. Without this competition process, this also means that the appointed or existing suppliers or service providers face no competition. Therefore, they have no incentive to compete. They have no incentive to improve the quality of their services or to innovate, because they know that they would be appointed, for example, for longer periods of time. There's no threat to them, being appointed as service providers, because no other service providers will be considered by the residential estates, because there's no competitive process in the appointment of the service providers. And obviously then that also means that consumers are forced to accept whatever quality or prices are offered by the appointed service providers for as long as there is no competitive process in relation to their appointment. The second issue that the Commission has identified, or theme of concern that has come up in the complaints, is that residential estates tend to conclude long-term or evergreen exclusive agreements with suppliers and service providers. The main issue here is obviously that then the existing suppliers are locked into the estate. There are no opportunities for competitors to be able to come into the estate and offer their products or services. And this is obviously harmful for new entrants, especially entrants that are, small and medium enterprises and those that are owned by historically disadvantaged individuals. And without the competition, the other key concern that arises here is that consumers are then deprived of the power to exercise their choice and to choose which suppliers they want to use, because there isn't a diverse and greater pool of suppliers available in the state for them to choose from. And obviously that also means that then consumers are subjected to the prices that are offered by the existing suppliers who face very little or no competition, and they have to accept those prices in most cases. And those prices are obviously, or can be in most instances, excessive prices, because those suppliers or service providers face very little or no competition in the services and goods that they offer in the residential estate. The third concern or theme of concern that we've identified from the complaints that have been investigated by the Commission relates to the fact that estates also draft these rules and regulations that are restrictive, with the assistance or in consultation with other service providers who have been appointed to operate in the residential estates. I mean, it is understandable that residential estates, and in that context, obviously, homeowners associations and body corporates do not always have the technical expertise to decide whether suppliers or service providers meet the professional requirements to operate in the industry and what those requirements are. And therefore, they then solicit or cooperate with, these professionals or service providers in order to set up some rules and evaluation criteria for the appointment of service providers. But this raises concerns, because then, those service providers that are then consulted may, justify or, just encourage the residential estate to adopt rules that can be unnecessarily restrictive or impose burdens on new suppliers that will not, that they will not be able to meet in order to basically protect their commercial interests and, prevent new potential entrants or competition in the residential estate. So that is the issue that then arises in relation to consulting service providers when preparing or adopting rules and regulations for the appointment of service providers. And we'll touch, more on this when we talk about the competition principles that the Commission is advocating for. The key thing here then is that, residential estates must ensure that their processes are fair, transparent, and objective. And I'll just now hand over to my colleague Fadani, who will take us through some case studies to just give some real life examples on the issues that we have highlighted.
Thank you, Betty. Good morning, colleagues. My name is Vathani Mandla, and I will be taking you through the case studies. We wouldn't be the Competition Commission if we did not have diversity, even in our presentations. I will start off with the operation of an estate agent or a single estate agent in residential estates. We have found that in most cases, residential estates appoint a single estate agent, and this estate agent is responsible for an array of things, including sales and rentals. The estate agent is often related to a member of the body corporate or homeowners association, and this does pose problems for us. We also found that the period of appointment is evergreen, so they continue to serve that residential estate for an indefinite period. We have also noted that there are instances where there is no competitive process in the appointment of that estate agent. This is concerning for the Commission. Now, we have also identified competition issues in this conduct within the residential estates. We note that that particular estate agent often faces no or very little competition, and that does not incentivize them to offer proper and good services to the residents of the estate. In so doing, the consumers have no options or have very limited options and often have to take whatever price that estate agent offers. Now, we wouldn't be the Competition Commission if we didn't have viable solutions. In doing so, we do suggest that residential estates and homeowner associations appoint more than one estate agent, and that in their appointment, they do not sit or hold office for more than 3 years. So anything above 3 years is not competitive at all. We also suggest that the appointment of an estate agent is done through a competitive process. But we are not prescriptive at all. The competitive process could be an open tender system, an advert, and I could imagine that an advertisement in your local supermarket is at very little cost. Betty? Next slide, please. Thank you. Another theme that we have noticed in residential estates is the provision of utilities. In this case, we find that residential estates have one service provider for each utility, or in some cases, they have one service provider for an array of utilities. In respect to gas, we have found that estates have a service provider that they use for the provision of piped gas. The competition issues attached to this are that the rates that are charged to estates or residents in the estates are not at the same level of the municipality and are often at a higher cost that is detrimental to consumers. We also note that in the case of piped gas, in order for someone to live in the estate or use the facility, it is compulsory for them to use piped gas to the exclusion of all other alternatives. You could have in mind the idea to use cylinders, 9 kg cylinders or whatever cylinders you prefer to use, but that in often cases is not available to you. The Commission's approach to this is simple. We do encourage that you rotate service providers, and that in doing so, you limit the duration of each service provider. During your duration of the service provider, you could also consider reviewing their services to ensure that their services are in line with the industry standard. Betty, please. Next slide, please, Betty. Thank you. Another theme that we've noticed is in the provision of fiber and internet connection services. We note that in most residential estates, there is a use of a closed network system, or they prefer to use the installer's infrastructure exclusively. We also note that there are competition issues attached to this. For instance, if there is one service provider, that means less competition at higher prices for residents. This is not in favor of competition regulation. The Commission's approach in this is quite simple as well. We prefer that residential estates use an open network system, and that we note that there is an investment that goes into installing infrastructure. But however, there are other ways to recoup the investment. For instance, you could have a reasonable return on investment by charging connection charges. So other service providers within the area could also use that specific infrastructure. Betty, next slide, please. A key theme that we noticed, and that, as my colleague said, encouraged the interaction with SACAP, was in the built environment. In most cases, residential estates will use one category of professionals within the built environment. In most instances, it is an architect, and this is to the exclusion of all others, specifically your technologists and your draftsmen. This is quite concerning because when residents in the estate need work done, they are able to select other professionals who can also offer the same services at a much cheaper price than your typical architects. We do also note that there are competition issues in this conduct. For instance, there is limited or no competition in that arrangement. There are higher prices that are charged to residents. The appointment process of that specific category of professional, it's not competitive at all. In most cases, the homeowners association or the body corporates cannot really detail when the service provider was appointed. And we do suggest that there is a rotation in the use and appointment of these service providers. Betty, next slide, please. The Commission's approach in this is quite similar to those in other themes. We do suggest that you make use of professionals in various categories. We also suggest that homeowners associations and body corporates appoint more than just one category of built environment professional. For instance, your draftsmen, your technologists, your senior technologists, and your architects. Sometimes it would even be better to have on the panel more than just one of these categories. We also suggest that each category submit their own plans to the municipality, because in our engagements, we have noted that these categories can on their own submit plans to the municipality, who is also capable of reviewing these plans and suggesting whether they're up to standard. Thank you, Betty. I will hand over back to you.
Thanks, Fatani. I will just then take us through the competition principles that I had noted earlier that the Commission is advocating for. And these are 6 principles that I will go through. So the first principle that the Commission is advocating for, that, you know, residential estates and those being body corporates and homeowners associations should take into account when implementing or adopting rules relating to the appointment of service providers. So the first one is that the appointment of suppliers and service providers should follow a competitive process. And this is obviously important in order to make sure that there is a large and diverse pool of service providers that the residents of the estate can choose. And also, obviously, this helps to make sure that then these service providers and suppliers also compete for the provision of goods and services to the estate. the Commission is not prescriptive at all in terms of, what a competitive process needs to look like. So it's not prescriptive in terms of, the fact that, residential estates should always run a tender process. It could be, through an RFQ, an RFP that is, sent out to a selected pool of suppliers. The Commission is not prescriptive at all, as long as the process is competitive and inclusive. The second relevant principle is that the evaluation criteria and the appointment processes that are adopted and used by residential estates need to be fair, transparent, and inclusive. For example, the evaluation criteria and process that is undertaken is to be communicated to all existing suppliers and potential suppliers so that they know what requirements are in place and what they need to meet in order to be able to be appointed as a service provider or supplier in the residential estate. And the key thing here that the Commission is also advocating for is that when suppliers and or service providers do meet the evaluation criteria, they should be approved and appointed by the residential estate in order to be able to, make sure that the estate has a diverse and large pool of service providers that can be used. I'll just then move on to the next set of principles that the Commission is advocating for. The third principle relates to the exclusive long-term agreements that we have identified in the complaints received by the Commission. And here what the Commission is advocating for is that suppliers and service providers should be appointed for a set period of time. So they should not be appointed for a period of time that is long. And also what the Commission has obviously seen in the investigation of complaints is that in some instances, service providers' appointments are renewed automatically without going through a competitive process. So what the Commission is advocating for is that a homeowners association and body corporates should refrain from concluding agreements that are automatically renewed after the initial period without engaging in a competitive process. And the homeowners associations and body corporates should also refrain from concluding long-term and exclusive agreements or agreements that are evergreen. And this will obviously assist in making sure that there are new opportunities for potential suppliers to come in. Whilst the Commission, considers that, the duration of the contracts should be 5 years or less in order to allow for a more regular rotation, as noted by my colleague earlier. There are specific instances where the Commission, in its investigation might be of the view that in that particular type of service and considering the competitive dynamics there, maybe a period of 3 years may be more appropriate. So the Commission generally would advocate that, the duration should be 5 years or less, and obviously subject to the specific circumstances of each case. The fourth principle relates to the participation of SMEs and HDI firms. And here the Commission really is advocating that residential estates should, consider, the service providers that they have on their panels or on their list of, approved service providers and suppliers, and consider, increasing the number of firms that are SMEs and the number of firms that are owned or operated by HDIs. Commission is also not very prescriptive at all, is not prescriptive at all in terms of, what measures could be adopted here or what target residential estates should have in terms of, the appointment of SMEs and HDIs. But the key principle is that there should be an increased participation of SMEs and HDIs in the services and goods that are procured by residential estates. And the last two principles that the Commission advocates for, the first one is, the implementation of measures to increase transparency in the application and selection processes of residential estates. Here again, the key principles that residential estates should be transparent on the processes that they follow in terms of evaluating applications, but also in selecting suppliers. Again, here, this information should be made available to all potential suppliers, should be, published for example, in the website of the residential estate, so that anyone who would like to offer goods or services to the residential estate can go into the website, look through the information, what they need in order to be appointed. And the other way in which residential estates can be more transparent in their processes is just to give reasons to unsuccessful applicants, especially those that are SMEs and HDIs. This really does help them to sort of improve where they need to improve in order to make sure that they meet the evaluation criteria of the residential estate. And the last and also very important principle relates to consumer choice. And the principle that the Commission is advocating here is that homeowners associations and body corporates should improve consumer choice by appointing several suppliers and service providers for each service that is provided in the residential estate. And obviously this is very important because then it allows consumers or residents in the residential estate to be able to choose or pick, from a larger and more diverse pool of service providers. And if there is a larger and more diverse pool of service providers, there will likely be competition between those service providers. Therefore, consumers can benefit from better quality of goods and services and also from competitive prices. So these are the principles that the Commission is advocating for and that residential estates should take into account when they adopt rules and regulations in their residential estates. And in conclusion, really, what I think is the key message here that's coming out of, the case studies, this presentation, as well as the opening remarks, is that, homeowners associations and body corporates should really refrain from imposing rules and regulations that restrict competition in the market. And they should review their current practices as well as their existing rules and regulations to make sure that these do not restrict competition and they are inclusive. The Commission really encourages residential estates to adopt measures that will ensure that their practices and that their current rules comply with the Competition Act. And this can be done by taking into account the competition principles that the Commission has shared today. And that is the end of the presentation, and I will now hand back over to Ms. Mutau. Thanks.
Thank you very much to Betty and Fatani for that insightful presentation on the cases, that the Commission has investigated and what the issues are in that regard, and what can be done to try and resolve some of those issues to ensure that they don't come up, but also to ensure that consumers have better choices, have got more choices of service providers, and therefore are better able to even negotiate prices, but also, again, principles that are looking to open up the market so that SMMEs and firms that are owned by historically disadvantaged individuals can also enter the market and participate, as service providers. Before we move on to the panel discussion, I would just like to note that I do acknowledge the questions that have been posted to date, up to now, and we will be answering them at the Q&A session. I do encourage everyone to please do send through your questions, post them in the chat function, and please do as well indicate to whom the question should be directed. So we will now move on to our panel discussion. I will introduce our panelists and I will ask them to turn on their cameras as I do so. Perhaps let me first start with introducing Mr. Shadrack Rambau, who is a principal analyst in the advocacy division. Mr. Shadrack will be facilitating the session for us. I will then like to welcome Ms. Bessie Hlophe, who is the Legal and Compliance Officer at the South African Council for the Architectural Profession, that is SACAP. Welcome, Bessie. And then I'd like to also welcome Mr. Jeff Gilmore, who's the president of the Association of Residential Communities. Welcome, Jeff. And I'd now like to welcome Ms. Lihle Ntombela, who is the Legal Services Manager at the Community Scheme Ombud Services. I would also like to welcome two of her other colleagues, Ms. Karen Blaise, who's the Gauteng adjudicator at CSOS, as well as Murendeni Radipanda, who is the governance officer. As you can see, everyone, we have a full panel. I'm really hoping that we will really get some great insights, some great ideas from the panelists here in terms of how we promote pro-competitive rules and regulations in residential estates, you know, for the betterment and for our consumers who do reside in these estates, but also for service providers that are saying we want to operate in these residential estates and offer these services. Mr. Rambau, I'm going to hand over to you and to your panelists. Thank you.
Thanks a lot, Karabo, and good morning, ladies and gentlemen. Perhaps before we start, I'm just going to outline a few housekeeping rules for the session. One, we only have 45 minutes for this session, which means that I will be allocating a total of 15 minutes per organization that is part of the panel. Two, I would actually request our panelists to switch on their cameras whenever they are requested to speak. And then lastly, at the end of the session, I'm going to give each organization 1 or 2 minutes for their closing remarks on the session. As I have indicated, we only have 45 minutes, perhaps without any further ado. The first question that I have on the rules and regulations of residential estate will be directed to the CSOS. You have listened to the presentation by the Commission and the kind of complaints that the Commission is currently investigating relating to rules and regulation within the residential estates. The first one, it's actually directed to Ms. Ralipada. What is the role of CSOS, or the role that CSOS can play with regard to these rules and regulations? I know that there might actually be some kind of an overlap or concurrent jurisdiction which exist between the Commission and CSOS on these issues. And perhaps you can also touch on that issue. Ms. Ralipada, over to you.
Chair, I would ask that I switch off my camera because my bandwidth is really bad. So I will answer the questions, but I will just not be able to be on the camera for the purposes of
that is noted.
Right. In terms of the mandate of CSOS, so CSOS has been established in terms of the Act, which is the CSOS Act of 2011. We have a mandate in terms of Section 4 of our legislation to govern community schemes. The community schemes that would include all residential estates, that is body corporates and homeowners association. The Act requires that as CSOS, we take custody of all governance documentation, that is all MOIs, constitutions, rules and regulations for community schemes. But also that we regulate, monitor, and quality control those governance documentations. Currently, we have the ability to both take custody and regulate and quality assured documentation for body corporates. And that power has been given to us in terms of the Sectional Title Schemes Management Act. That then gives us the ability to be able to regulate the conduct and rules of body corporates, and that allows us then to be able to point out when schemes do have rules that are contrary to competitive behavior. So in our current framework, we do then point out that they cannot have rules in body corporates that require schemes to use specific service providers, specifically as it relates to the use of specific estate agents, as it relates to the use of specific fiber companies or maybe rental property agents. The legislation so far has not been gazetted as it relates to homeowners association. So there's limited ability in terms of our ability to have oversight in terms of the rules for homeowners association. So far, what we do only is take custody of their documents. Where schemes voluntarily request it, we will then quality assure and quality control that documentation, and we will then point out to them if there is anything within the documents that is anti-competitive. But in terms of specific legislation, there is no specific legislation giving us authority to prohibit rules of that nature in homeowners associations. As was stated by the chair, we do have currently concurrent jurisdiction with the Competition Tribunal because the legislation for which governs homeowners associations, which is the Companies Act, prescribes that if there are any rules as it relates to governance documentation for companies, that dispute needs to be taken to the Competition Tribunal. So there is that concurrent jurisdiction currently with that institution.
Thank you, Ms. Ralipada. It's actually very interesting to hear that there might actually be a scope to work together here due to the overlap or the concurrent jurisdiction that I have referred to. Still on CSOS, and I will be directing the next question to Ms. Blaise. We just want to find out here, have you received similar complaints in the past, either from residents or competing service providers relating to these exclusive rules and regulations, i.e. homeowners who are not able to choose service providers of their own choice, or rules that exclude SMEs from providing services in the residential estates? We want to find out here if you have received these complaints in the past. How have you dealt with these complaints? And perhaps you can identify few of those complaints that actually stood out for you and the organization. Ms. Blaise, over to you.
Thank you, Mr. Chair. Yes, these are ongoing complaints. Many of our complaints refer to rules of the scheme, both in homeowners associations and in bodies corporate. And the complaints frequently relate to the rules with regard to contractors, such as plumbing contractors, electrical contractors, frequently estate agents, because the rules frequently state, which is anti-competitive, that certain estate agents only may be used. Most recently, in fact, as recently as last week, I had a complaint from an estate agent. Unfortunately, that doesn't fall within the CSOS mandate, where an estate agent applied and said, we, there are certain estate agents only that may be used in the scheme, and we have to give 0.88% of our commission back to the developer. Now, an estate agent we don't have jurisdiction over that particular, it must be an owner that in fact applies to CSOS, but that is generally, that is incorporated, or was incorporated in their rules, and that certainly, as you can imagine, is very anti-competitive. So those are the types of rules that are coming through, which certainly should not be there. That was for an HOA, and that's certainly something that we hope in the future will be incorporated into the CSOS Act. That should not be there.
Ms. Blaise, can you perhaps indicate how have you dealt with such complaints in the past?
Well, when it comes, as my colleague previously stated, the rules for bodies corporate must be sent to the CSOS to oversee, and we must approve them. And a rule like that is certainly contrary to the Constitution of the Republic of South Africa, but also it's anti-competitive and it will not be approved. But if it is referred to us by an owner in a homeowners association, and everything, as everybody knows, a rule such as that, or rules and legislation in general, must be informed by the Constitution. And so if something like that has to be referred to me in an adjudication, I will find against the Homeowners Association because that type of rule can certainly not be permitted to be enforced by the Homeowners Association for various reasons, one of which I've just mentioned. It's certainly unconstitutional, it's anti-competition, and for many other reasons. So it certainly will not be allowed to pass constitutional muster, etc.
Thanks, Ms. Blaise. I'm going to pose similar questions to the ARC.
Yes.
Mr. Jill Moore, can you indicate what is the role of the ARC with regard to these exclusive rules and regulations as presented by the Commission?
Thank you, Chair. Firstly, it's important to note that the association is a voluntary organization comprising of residential community schemes that choose to be a member of the association. And essentially, our broad role is to provide best practices to a homeowners association or a body corporate in respect to all practices. And that would include practices in relation to rules and regulations. So we provide a service to our members which assists them to construct and implement rules and regulations in a consistent, fair, and equitable manner. What is important to note, Chair, is, and it's been raised a couple of times during the presentation, that it may be implied that a homeowners association appoints, and the word appointing could be misleading, Chair, in that it gives the perception that a homeowners association appoints plumbers and architects and estate agents, etc., etc. The only appointment of an estate agent would apply to a developer in the early stages of development, where a developer may partner with an estate agent to run their sales arm to sell land to potential buyers. An HOA doesn't appoint. What an HOA does do, through a contractual agreement between the member and the homeowners association, is to ensure that let's use estate agents as an example, to ensure that any estate agent that is practicing in the community is familiar and aware of the rules and regulations, so that the estate agent is more empowered to offer the best possible service to its members. We are of the view that a member is entitled to use whoever they wish to use, so long as via the contractual agreement, the member ensures that the estate agent, or whatever the case may be, is is properly capacitated and registered with the Homeowners Association to ensure compliance with the rules and regulations as it would pertain to questions or comments or deeds of sale or offers to purchase that any particular buyer or seller wants to engage with. So it is not true that a homeowners association would go out about and appoint various service providers. And it is certainly in our experience, and certainly not with our members, a correct reflection that we would instruct any member that they have to use a certain plumber or a certain architect or a certain estate agent, but simply that they need to follow a process. And I know they have a question later on, which I'd like to deal with in more detail then. So our role, in a nutshell, is to provide best practice to residential communities to ensure that they follow good processes and good practices when applying their role as a member of the Homeowners Association.
Thank you, Mr. Gilmore, for clarifying the role of the ARC. I've got two follow-up questions to the issues that you have just raised. As a voluntary association, Mr. Gilmore, does it mean that there will be residential schemes that are not part of the ARC? That is the first one. The second one, you have indicated here, Mr. Gilmore, that there are situations where the homeowner association does not appoint. Are there situations where you do appoint service providers within the residential estate?
So yes, it does not necessarily mean that every single community is a member of the association. Obviously, we encourage that, but it is a voluntary association. The second point is one needs to differentiate between the appointment of service providers to conduct estate activities. So if, for example, the Homeowners Association is appointing a landscaping architect for all the common areas, then of course, following due process, the Homeowners Association would go through a normal, formal, non-competitive process to appoint such landscapers. It is very unusual for any homeowners association. This is based on our own experience, and we've been operating since 2008, that any homeowners association would compel a homeowner to appoint a particular landscape architect. What may happen, as I've raised earlier, Chair, is that in the development phase, one may find that the developer would recommend certain landscape architects that have gone through a rigorous process. But that's an issue that the Commission would need to take up directly with the developers and not the Homeowners Association or the body corporate. Thank you, Chair.
Thank you, Mr. Gilmore. Still with you on the ARC issues, we just want to find out here, Mr. Gilmore, whether you have received similar complaints either from residents or service providers. And these are complaints relating to exclusive rules and regulations, as the Commission has discussed in the presentation. And the second part to my question will be the measures that you have taken or you have put in place to perhaps address these concerns. And just to indicate, Mr. Gilmore, that we take note that any measure that you will be implementing, of course, it will be limited to your members and your members only. Over to you, Mr. Gilmore.
Quite right. And then, Chair, we are not a regulatory authority, as has already been presented by CSOS. We have a strong relationship with CSOS, and we assist each other greatly in encouraging and making our members aware of where perhaps they need to revisit their rules and regulations. So we do receive, yes, we do, complaints from a owner, and we encourage always to advise homeowners that they need to set up, and most residential estates have an internal dispute resolution process where any member that feels aggrieved regarding any matter in our rule and regulation, and I know we're referring today specifically with rules that relate to the governance of suppliers and providers, and we would then be in contact directly with the Homeowners Association, whether a member or not, Chair, to encourage them to engage with such individuals who feel aggrieved, and would encourage them to follow the laid down standard processes in relation to the internal dispute resolution process. And if that fails, we even encourage them to use CSOS to deal with those particular matters where it falls under the jurisdiction of CSOS. Thank you, Chair.
Mr. Gilmore, am I correct to conclude from what you have just indicated that even though you are not a regulator, there is some scope where the Commission can actually work with the ARC in some of these matters?
Indeed. I was going to pose the question a little later, Chair, in relation to the quantum of such complaints and disputes, and advise all member estates that the association is always on hand to assist any homeowners association with any specific matters, because one must recognize that homeowners association are made up of volunteers who give of their services to serve on the boards of directors. And one of the great benefits of an association is to ensure that they are made aware of such issues. So we would welcome any initiatives or any referrals to the association who would only be too pleased to assist. And in most cases, if that happens, homeowners associations are then encouraged through their boards of directors to address such issues. You know, if I had to go through the 6 principles as presented by the Commission earlier, I couldn't come up with any one principle of those principles that I could necessarily disagree with. And in fact, I would go further, Chair, to submit that that most homeowners associations would not disagree with that either. One must recognize, however, that there is a contractual agreement between the owner of a property in a community and the homeowners association. And one needs to be careful, and I see there was a question raised earlier from one of our member communities in relation to the contradiction with case law and common law around the application of our processes as it relates to contracts and the contracts that are in place through a homeowners association and the member. But we would welcome any interventions and further discussion and participation in workshops, as will many of our communities in such deliberations.
Thank you, Mr. Gilmore. Let me now turn over to SACAP. Ms. Hlophe, I know that we have actually worked extensively with SACAP on some of these issues, and we really appreciate your cooperation in this regard. We just want to find out, Ms. Hlophe, and this will be for the benefit of the attendees as well. What has been your experience and the experience of your members regarding the appointment of service providers in the architectural profession within these residential estates?
Thank you for your question. Our registered professionals have had a negative experience in relation to the exclusionary rules of homeowners associations and body corporates. SACAP has received numerous complaints from registered professionals and residents of these residential estates concerning these exclusionary rules. The rules are seen as unfair, as registered persons who are competent and qualified are being prohibited from rendering architectural work and fairly competing in the market. Thank you.
Thank you, Mr. Hlophe. I mean, I know you have actually touched on the impact of some of these artificial barriers to entry that are created by these rules and regulations. Can you perhaps elaborate a bit more, maybe on the effect on your members and perhaps the consumers of these services?
Thank you for that, sir. Basically, the issues that we are seeing or the issues that we are facing or the complaints that we are receiving, they are relating to the unfair competitive processes of the homeowners associations when selecting architectural professionals to provide architectural services in their residential estates. These exclusionary rules and regulations prevent other categories of registration who are competent and qualified as prescribed by the identification of work policy. They are basically excluded from entering the market, and consequently, this limits the competition between the architectural professionals and it limits consumer choice because residents of these residential estates are limited to only use professional architects that have been approved by these residential estates. We also have a situation where the residential estate selects, obviously, and approves specific professional architects to draw plans in these estates for long periods. This conduct creates unfair competition and is harmful to the architectural profession, and professionals are being excluded from offering services that they are competent to offer. We also have the issue of the fact that this conduct is very harmful to the residents who, because of these exclusionary rules, are not able to select service providers of their choice. This conduct further constrains them from negotiating the prices for the architectural services that they are receiving because there are specific professional architects that are being allowed to render architectural work at their specific prices. Our registered persons obviously have come to us on numerous occasions with this issue. We've had lots of complaints on this issue, and we've had a lot of engagement with the homeowners association trying to help our registered persons. They are also of the view of the fact that they are not getting enough support on these issues from SACAP and other bodies, and their frustration is totally understandable in our view because there is no justifiable reasons in law for these exclusions that are currently taking place. Thank you. I hope that gives more of an elaboration. Thank you.
Yes, it does. Perhaps lastly, Ms. Hlophe, what is perhaps the advice that you can give to the listeners? I'm actually hoping that some of the attendees will be representatives from homeowners associations / body corporates.
Thank you for that. I think what is most important for us as SACAP to the homeowners association is that there is an applicable identification of work policy that is in place, it's gazetted, and it should be they should be able to be using that IDOW. So basically the CBE, which is the Council for the Built Environment, has in terms of Section 20 of the Act, together with SACAP, determined the identification of work policy. The identification of work policy details the different categories of registered persons, those being professional architectural draftsperson, professional architectural technologist, and professional senior architectural technologist. So it also identifies the scope of work for every category of registered persons in the architectural profession. The Homeowners Association must apply SACAP's IDOW policy as prescribed. In our view, the application of the IDOW will contribute basically to an end of these exclusionary rules and prohibitions. The homeowners associations and body corporates will obviously be accepting building plans by determining if the person who's submitting the building plans is registered and is categorized as capable of performing that level of work in the IDOW, because the IDOW provides the qualification, tertiary experience, as well as experience in the industry, and it also provides different types of work, examples, listing all the different examples of work that can be rendered. Now, the situation here is that it's very unfair to the people who have dedicated their lives to be in the architectural profession and obviously have taken all the right steps to be persons who are able to compete in the market and to perform work in these estates as well. So it's really unfair to them because the IDOW does allow them to render work in these homeowners associations and body corporates. However, they are still being prevented from doing so. So we also obviously advise that homeowners associations should, moving forward, ensure that they follow a fair competitive process when selecting architectural professionals to provide architectural services. The process should be inclusive and to enable service providers across the various categories of registration to submit their building plans and to compete fairly against each other in the market. As SACAP, we also propose to the Homeowners Association that the identification of work should be used as a determining factor when they are drafting their regulations and their rules and their design guidelines. And this is in relation to the homeowners associations that are still developing their rules or their design guidelines. And then obviously to the ones that have these rules and design guidelines in place, we also are of the view that they can be updated or they can be reviewed to be in line with the applicable law, which is the identification of work. Thank you very much. Oh, furthermore, I just want everybody to know, Chair, that SACAP, we have issued a circular. This circular was done by the Competition Commission. We've issued the circular to a various homeowners association, and we believe they should at least give us some some positive responses to the circular that we have issued, identifying these issues and identifying our proposals to them as SACAP. Thank you very much.
Thanks a lot, Ms. Sope. Back to ARC, Mr. Gilmore. We want to find out here, based on your experience and that limited oversight that you have on the rules and regulations of these residential estates relating to the appointment of service providers. What is the process that is normally followed in the appointment of these service providers? I mean, of course, we are taking note, Mr. Gilmore, that your response will be limited to those services where members of the ARC are required to appoint service providers. And perhaps the second part of that question, we want to find out whether do you have measures in place to ensure that these appointment processes become not only transparent and fair, but also they become inclusive. Thanks, Mr. Gilmore.
Thank you, Chair. So our member communities, our member estates have laid down policies and procedures in relation to, and let's call it, for want of a better expression, registration, where a particular need may have arisen amongst the board of directors, keeping in mind that every one of these estates has a memorandum of incorporation or constitution in place, and they have their rules and regulations adopted by the members of the communities and not necessarily the estate manager or the managing agent or the directors themselves. They have laid down policies and procedures that would allow for these service providers, estate agents, whatever the case may be, to apply to become registered with the Homeowners Association, not necessarily by implication to restrict anti-competitive measures, not to prohibit certain providers from providing services, but rather to encourage the participation of such service providers in the good governance of the community in general. So if one had to take an estate agent as a typical example, Chair, an estate agent or an owner that wishes to use an estate agent, our advice and our suggestion to all homeowners association is they do not limit the number of estate agents that are willing to practice. Do they have a mandate to sell property on the estate? Are they in possession of the Estate Agency Affairs Board of a Fidelity Fund certificate? Have they met all health and safety requirements? All set for proper reasons and proper purposes and proper motivation to provide the best possible service. And it is the Homeowners Association that then facilitates that process by encouraging these service providers to participate without limiting. And it is always our suggestion, and I don't know of estates that I could identify that aren't fulfilling that. If there are, and I'm sure there are, residential estates that put anti-competitive, not through a direct result of them wanting to be anti-competitive, or any estate wanting to limit the number to keep friends in place, or service providers that meet criteria that are not achievable by many in the market. That is not the intention. And our approach to it is always to encourage that. But you know, any resident or member or service provider will have a right to review those policies and procedures that any service provider may need to comply with to become registered. And it's registered only with the Homeowners Association to ensure that proper safety, proper security, and proper governance processes are practiced by that particular provider, not on an exclusive basis, but on an inclusive basis. So that's really an important point to keep in mind, Chair.
Thanks a lot, Mr. Gilmore. Perhaps a follow-up question, which is related to my first question. We just want to find out, Mr. Gilmore, and this is what was also presented by the Commission in our earlier presentation, whether in cases where your members are required to be appointing service providers, do you appoint these service providers for a limited duration as required in terms of the principles that we have earlier outlined? And the second part of that question is whether do your members regularly review their own contracts with incumbent service providers?
Yes, indeed. That is a requirement of a director's fiduciary responsibility, Chair, to make sure that firstly, the policies and procedures that are in place are fair, equitable, open, and transparent. And secondly, that the policy would indicate through its control measures the review of such agreements that it has in place. Keeping in mind, Chair, and maybe a reminder to the House, that the Homeowners Association does not appoint an estate agent to sell a particular property. And I use that example because it is close to mind and it is something that is topical at the moment. The HOA does not appoint a estate agent to sell someone's property. HOA simply has a process in place to ensure that that estate agent is as required by law and the requirements of the then Estate Agency Affairs Board to make sure that they are in possession of all of the tools and all of the certification and all of the requirements as dictated, not by us, but by the regulatory authority that would be in place to regulate. So certainly the members of the Association of Residential Communities encourages, and in most cases, and I'm trying to rack my brains to think of any member estates that do not have a review process in place, should they have a registration system to ensure that providers meet the minimum criteria that is in place. But that criteria should not be exclusive, Chairman, and that criteria should not be a criteria that's in place to prohibit the active participation in all service provider categories. That is not the intention, as far as my experience shows, Chair. I hope I've answered your question.
Yes, you have, Mr. Gilmore. The next questions will be directed to CSOS, and I will request Ms. Ntombela to switch on your camera and answer the questions that we have here. Ms. Ntombela, in the presentation, the Commission highlighted some competition principles. We just want to find out from the views of the CSOS, what are your views on these competition principles that we have highlighted in the presentation? And perhaps you can also indicate how best can these principles be adopted and implemented in these residential estates. Thanks. Over to you.
Thank you, Shadrach. So I think as a start, Section 39 of the CSOS Act gives the CSOS jurisdiction to preside over disputes which arise from governance documents such as rules, regulations, constitutions, and other scheme documents. And as my colleague Karen already alluded, we do get those disputes referred to us by home consumers and other interested and affected parties. And as a general rule, we must remember that we can't have rules and regulations, even provisions in a contract between service providers and the HOA or the body's corporate, which trump the prevailing legal principles or in conflict with our law. So for instance, you can't have rules which permit some sort of arbitrary discrimination against certain service providers. And because in doing so, you've got to bear in mind that there's a constitution at play that's now being breached. You've got your Computer Act as well as your Competition Commission Act and other acts that you are now transgressing. So we don't allow rules that are arbitrarily or that seek to discourage competitive behavior. And we are authorized as the CSOS to issue orders either calling for that certain provision to be repealed or to be revised by the Homeowners Association. And once they're in order, we obviously would issue some sort of endorsement in the form of a certificate. So generally, when such matters are brought before us, we do actually issue orders that either call for the certain provision to be scrapped off or to be revised. And but we must also remember that sometimes the rules might appear, above board. However, when you look deeply into the practices that are happening on the ground, you might find that there is some sort of a conduct which seems to favor certain, service providers over others that is actually taking place within a homeowners association or bodies corporate, even though the rule seems to be, above board. And in these instances, we do issue practice directives which seek to guide the sort of behavior within or the allowable behavior and conduct within community schemes. What we've also done recently, or what we're currently doing, the CSOS is in the process of reviewing its legislation. So this is the CSOS Act as well as the Sectional Title Schemes Management Act. And what we are looking into introducing there or including is a provision which talks to the tenure of service providers that the community scheme uses. So for instance, we have, and we're doing this solely to promote transparency and also good governance, because and in doing so, we're going to be getting rid of these evergreen contracts because they are a bit of a nightmare for us as the CSOS also, because there's a lot of unbecoming conduct that gets hidden under these evergreen contracts. So in order to do away and to address that situation, we've decided to include certain provisions in our legislation legislation, which seeks to put a time frame on the various service providers that a scheme uses. So these are going to be ranging from auditors, whatever other service providers that they are using. So they would need to align their contracts with obviously the legislation once it is passed and it's in effect. So that's another measure that we have put in place in order that we are looking into as a long-term solution to deal with this anti-competitive behavior that we are seeing in the industry. What we have also done as the CSOS, in order to promote competition and the inclusion of HDIs, we do have a lot of schemes who struggle when it comes to managing and complying with the governance requirements that are set out for community schemes. And in this regard, we have established a panel of HDI managing agents. So whenever a community schemes, and these are in all provinces, if a community scheme struggles, with appointing a managing agent, they're more than welcome and to appoint one of the managing agents on our panel. And we do provide ongoing training to these managing agents. We've got a code of conduct that guides the behavior or the conduct that's acceptable and not allowable. And we also provide consumer awareness training and education to community schemes. So during AGMs, community schemes are more than welcome to request the CSOS to be in attendance and sort of provide some, information sharing session on workshopping sessions on whatever issues pertaining to maybe voting rights or, the passing of rules, regulations, and the likes. So we are increasing our awareness on a regular basis. So those are the intervention measures that we have currently put in place towards addressing the issues that have been highlighted in as far as they relate to competition.
Thanks a lot, Ms. Ntombela. We are actually running out of time. Through you, Chair, can we get 5 extra minutes to conclude?
That's fine, Mr. Ramba. I'll allow for 5 extra minutes.
Okay. Thanks a lot, Ms. Mtau. Ms. Ntombela, in just 1 minute, we just want to find out here, over and above the principles that were discussed, I mean, are there other additional measures that you think will actually be applicable to deal with these exclusionary practices within the residential estates? You are on mute. You're on mute.
My apologies for that. So as mentioned, that we are relying on the legislation that's in place that does give us the powers to intervene. So we are relying on those changes. We rely on our practice directives that we issue, but there are currently quite a number of court cases court action that we're involved in currently, which deals with some of them deal with this issue of competition. So we are definitely looking forward to the outcome from the courts and to apply those and whatever, I suppose, further recommendations or suggestions that come from those, we would definitely be in a position to, implement. However, we're still relying heavily on raising consumer awareness in the form of conducting trainings and workshop sessions with homeowners, as well as the various community schemes, should they need our assistance. And obviously our dispute resolution mechanism that we have in place. We're also making use of that to ensure that this, and any anti-competitive behavior is nipped in the bud.
Thanks a lot, Ms. Ntombela. Back to you, Ms. Lope. I will be posing the same questions. The first one, whether those competition principles that we have highlighted, you think they are suitable and adequate to deal with competition issues within residential estates. The second one is perhaps whether over and above those principles that we have highlighted, do you perhaps have any other measure that you can suggest in 2 minutes, Ms. Lope?
Thank you greatly for the opportunity. With regards to the first one, I just want to say to the Competition Commission, It is much appreciated that they did develop these 6 principles to help curb this problem or to put an end to this problem. I think also our registered persons will be very much happy at the outcome or at these principles being now in play, because I believe they have attended to all of the issues that we mainly have, because the principles, when there was a presentation on the principles, they did make mention of the open tender system. They made mention of the issues on the period of employment, and also obviously putting an end to the unfair or the exclusionary rules, as well as the appointment of various service providers and registered persons. So I do believe that the principles are going to be very, very much helpful in the situation that we are faced in. And then over and above the principles, my honest view as SACAP in this situation, I believe what we will be doing as well in the meantime is we will be pushing the circular that we have received from the Competition Commission. We will also, in the past, we have been trying to get into meetings with relevant persons in the estates in order for us to at least conclude MOUs with them, or at least have some form of understanding that is signed in any manner, anyhow, just to ensure that they will also rely on us and we will also rely on them, obviously. And we also are still pushing the IDOW because the IDOW is just quite clear, and we also believe it is quite a solution to this problem. So we will be pushing on that. But I do want to say thank you for the principles that have been developed by the Competition Commission. And I do believe that this is a great change in our profession. Thank you.
Yeah, thanks, Ms. Lope. Mr. Gilmore, I'm sure you've got the questions, the 2 questions that I have posed.
I do, Chair, and I would like to echo the previous panelists in thanking the Commission for giving people the opportunity to come and engage. And without repeating myself, I just want to close off by saying that that the danger that is facing the residential community industry at the moment at large is that an impression of exclusivity needs to be avoided. And should it be seen, or should there be evidence that there is any form of exclusivity or anti-competitiveness or unfairness, that those matters should be dealt with, and we should deal with them via collaboration, awareness building, education of in one instance, the HOAs and bodies corporate themselves, but secondly, on the openness of service providers to engage with a homeowners association to best deal with these matters. But I think the principles as set down, and I speak from my own view here only, are sound, and we need to embed within all communications and awareness campaigns in our industry that that the doors are always open to service providers out there to engage with the homeowners association directly. And just to reiterate in closing, Chair, that our role and the role of the homeowners association is not to exclude people, but to include people, keeping in mind that every homeowners association has a policy and a procedure in place to ensure that these processes are applied. I see there was a comment made on the chat relating to the registration or the application of providers to practice their profession, and so long as they meet the criteria, albeit not competitive, inclusive, then everyone should be entitled to participate, so long as they meet certain guidelines as imposed not by the homeowners association, but by the members themselves. And most memorandum of incorporation, governing documents, constitution, and rules and regulations would outline that process. So well done to the Commission on initiating such a workshop, and I believe further workshops or one-on-one collaborations are important. Thank you, Chair.
Thanks a lot, Mr. Gilmore. Your responses to the last two questions also included your closing remarks. The same with Ms. Hlope. Ms. Ntombela, maybe in just under a minute, do you perhaps want to give your closing remarks?
Thank you so much, Shadrach. I think, like the rest of my colleagues, I would like to extend our gratitude to the Competition Commission for the work that has been done in this space, and we do see that it's a lot of work. And as the CSOS, we are happy to collaborate with the Competition Commission moving forward around these issues that affect the industry. And we'd also like to extend our gratitude to our colleague, Jeff Gilmore, who's always on standby, because this is, something that's going to require, in order to resolve these problems, we are going to require, the homeowners associations and other community schemes to come on board so we can have a collaborative solution. So I think thank you to all the participants and the role that you continue to play in ensuring a level playing field in this industry. Thank you.
Thanks a lot, Ms. Ntombela. Thanks to the panel for the insightful conversation. Let's keep the conversation going. It's back to you, Chair. Thanks.
Thank you, Mr. Rambau, and thank you to all the panelists for such an eye-opening discussion indeed. I think I'm very much encouraged from the discussions today. I'm very much encouraged that the principles that the Competition Commission is advocating for have been warmly welcomed, by the panelists that are sitting here, and I think more than anything, just the reception from everyone, to say, what we want, or we are willing and able to help the Competition Commission in advocating for these principles to ensure that the rules and regulations of the residential estates, are as pro-competitive as possible. And of course, I think the reception also to the idea of collaboration and cooperation, in order to ensure that we roll out pro-competitive rules and regulations, and that we transform these industries. We do have a couple of questions in our chat box. I will read these out and direct them to the correct panelists. But firstly, perhaps maybe let me respond to Christo and Penny, who indicated that they missed a portion of the session and wanted to find out whether the recording will be available. Yes, this recording will be uploaded onto YouTube later on. The recording can also be found on the Commission's website. I also just want to indicate that the joint circular that we've been referring to, that SACAP has been referring to, is also available on the Commission's website. So you can definitely make your way through there, and so that's where you'll find the document, and later on then the recording to this event. I am going to jump straight ahead into the questions that we've received. And I think I would also like to encourage participants to post questions as we go through. We do have a few more minutes available to us, so we would really be happy to take more questions from yourselves. The first one says that there is law which states that homeowners and homeowners associations have a contractual relationship. The question is, does the Competition Act have the power to override contents of such contracts as the rules, policies, or regulations are made in terms of these contracts? Lisa earlier in her, I think, closing remarks, or in addressing one of the questions, I think did respond to this from a CSOS perspective. And so I will then allow Ms. Khanyi to come in and provide a response specifically from the Competition Commission.
Thanks, Karabo. Maybe I can take both of the questions from John Dreyer, if that's okay.
That's fine. The second one is referred to one of the comments that we made regarding the Commission's approach to estate agents, and that Mr. Dreyer indicates that it is contrary to the Property Practitioners Act or regulations.
Okay, so on the first one, Mr. Dreyer, you are correct that the rules and regulations do make their way into the contracts that are then signed by residents. So the issues that are raised here today are about the contracts between developers, homeowner associations or body corporates, and service providers. It's a trifecta relationship. Sometimes it is bilateral. And so therein are the challenges that that were spoken about today tend to arise. And it's then those contracts or the way those are designed that are then forced down essentially then onto the contracts between the consumer or the resident and the HOA. But to then answer the question on the applicability of the Act, so the Competition Act would be applicable to then that relationship is economic activity essentially that would be agreed upon by those parties, be it a developer and a service provider or supplier, or be it an HOA and a service provider. And issues of exclusivity, and I think this brings me to your next question, which I think came up in the context of estate agents having exclusive mandates in particular developments. So exclusionary conduct is a prohibited conduct in the Competition Act, unless the firm can prove technological or efficiency gains that outweigh the competition harm. And so we do give guidelines on these matters. I think it came through today, around how these things could be managed. So if there is some kind of efficiency gains for an exclusive contract, for example, if the estate is very small or for whatever other reason that may be of efficiency or technological grounds, then there must still be competition parameters put in place, such as time frames for those contracts. It cannot be evergreen. And so these principles that were, I think, put out by the team here today are in the context of advising homeowners. But there are instances, as I said, it is prohibited conduct. So it is something we would investigate and look at on its own merits. But many of the complaints we get are from large estates who've been in or large, developments who've been in practice for or in existence for very many years and have these then exclusive relationships, and the Act is applicable in that context. Thanks, Karabo. I hope that clarifies.
Thank you very much, Kanye, Mr. Dreyer. I hope you are clarified on those points. The next question comes from Hannes Hendricks, and again relates to issues of architectural professions. He says that members of homeowners associations has the right to appoint an architectural professional to design the member's dwelling, or to see its property on condition that these architectural professions or estate agents has applied for registration. Mr. Hendricks further says that the registration process has a criteria which includes that a professional needs to attend an induction or orientation session, must demonstrate through its portfolio that the professional can and has designed dwellings within the architectural design rules. If a professional during the submission process are not able to design within the rules, a homeowners association has the right to terminate the registration. Perhaps I can ask Bessie maybe to come in from a SACAP perspective, given that I think this comment specifically relates to architectural designs. And then I'll also just ask Khanyi to come in as well, given our experience with the complaints that the Commission has been investigating regarding these registration processes that homeowners associations have in place. Bessie, perhaps let me start with you.
Thank you for that. In our view, the issue of submitting building plans and being requested to either submit proof of experience or to either submit proof of former similar submission in the past is only necessary whereby the person has applied for a special consent, for example, in terms of the IDOW, wherein they are trying by all means to show that they should be able to do this work because they've done it in the past, whether it was because the IDOW was not yet in place or anything like that. But it should have a reason behind it, because the IDOW does specify that certain categories of persons can perform work that are found in these estates. Therefore, it would be unreasonable to request that you provide proof that you have done this work when you are identified as capable of performing that work in the IDOW with the necessary experience to do so. Yes, thank you for that.
Okay. Just then to maybe add on to that, I think maybe a point of emphasis then is that the regulation of built environment professionals belongs to the regulators and not to HOAs and body corporates. And we find that with the complaints we get that, body corporates and HOAs essentially create new regulations that are artificial and inconsistent with the regulation that exists for those professions. With the built environment professionals, or maybe being particular to SACAP, there are various categories of registration, starting with the architects, followed by senior technologists, then draftspersons. And they, within the scope of their regulation, can determine, who is competent and able to do what. And even that very criterion of determination is evaluated on an annual basis. These are the engagements we've been having with them in the last few years. And so it's a regulatory function, that they, as the professionals, may be best placed to make those judgments on. So when HOAs or body corporates then, come up with new rules about why a draftsperson or a technologist or a senior technologist cannot do work within their state, which they are certified and competent and able, certified by a regulator, by law to do so, it is then an artificial and it is a barrier to entry that is being created. And I think that's the nub of the engagements we have with estates. Again, we made the example when we were earlier that often such rules are designed by the partner architect, that would have been appointed. And so they have vested interest, of course, in having that exclusivity. We've seen lists of, panels of, architects only, which bring a lot of concerns to us on, on for building work that could be undertaken by other professionals, as the professional, regulatory body has certified them to do. Hope that clarifies the issue then.
Thank you very much, Khanyi. Mr. Hendricks, I hope you are clarified on that one. We have another question from Ms. Silan Naidu, who says that from members' experience in our estate, CSOS has not been very helpful in getting disputes resolved. CSOS is approached as an alternative to going to court and hiring lawyers. But recent experience with CSOS is that the adjudicator dismissed a dispute without even looking at the merits of the dispute. The dispute was dismissed based on the fact that the member did not write the words "on behalf of members," even though evidence of mandates from members was produced. So it seems like CSOS expects you to draft your papers as you would for court. This defeats the purpose for CSOS. My colleagues from CSOS, Lihle, Karen, I don't know who wants to tackle this one. I don't know if you both want to come in quickly, just to respond to this one.
Can I defer the question or the response to Karen as in her capacity as an adjudicator?
Thanks, Lihle. Karen?
Certainly, thanks, Lihle. You know, we as adjudicators, we have to act within the four corners of the CSOS Act, very much like magistrates do. And in particular, Section 39 of the Act, which deals with disputes and the relief that we may provide. And so somebody can't come to CSOS and just ask for anything. The relief is specifically set out. So there is a judicial framework within which we work. And people have to read certain sections of the CSOS Act and the practice directives, which are set out on our website. So, you know, as I say, there's a framework within which people have to work. So you don't need legal representation, but you have to read those portions of the Act which I've set out. And in that regard, there are certain steps, procedures that have to be followed. So CSOS is exceptionally helpful, but you have to follow those guidelines. As with everything, you have to follow those guidelines. And so I can't answer to that particular question because I don't know what those particular facts are. But basically, that's what has to be done. Those guidelines have to be followed. And there are so many guidelines that are set out on our website very clearly and very cogently. And so that's what I would suggest people do. And that's as briefly, as succinctly as I can say it. Thank you.
Thank you very much, Karen, for providing a response. We do have a comment from Hendricks, which states that the panel that evaluates the plans submitted must not be allowed to design in the estate. And maybe it's not much of a question, but rather a statement or a comment. And indeed, Hendricks, if I am reading that statement correctly, this would help eliminate any potential conflict of interest that these panel or evaluators would have if they themselves were also competing for the services for which they are assessing. I don't see any more questions in the chat box. I see we are 5 minutes left, so I will wrap up and by inviting back Ms. Khanyisa Qobo just to do to give the closing remarks, but also to officially close this workshop for us. So this will be the last time that you are seeing me. I think thank you very much to the participants. Thank you to the attendees. Thank you for the questions and for the engagement. And let's definitely keep the discussions going. Thank you, Khanyi.
Thank you, Karabo. I think this has been very illuminating for us as well. Thank you to our panelists just for your time today and your insights. Thank you also to the participants. We hope this has been helpful. If you are a resident in an estate that perhaps there's some clarity on your rights and also a recourse that you could take. And even being a voice for change using the structures available within your body corporates and HOAs. And so we do hope to see changes in this space going forward. I think one of the big themes that have come through is just the multiplicity of role players in the space. I think it's clear that we may have to do, deep dive engagements with the sub role players that are emerging here as, being party to some of this this conduct. And so we certainly have mapped that out, and we'll be doing further engagement. There's certainly scope for further education and training, and as I indicated, we are starting off in this advocacy mode, hoping to create awareness and promote compliance. But in doing so, we will have to work with our other regulators. I think there is really scope for strengthening collaboration here. And so we are encouraged by your positive engagement and support, and we look forward to working with you further going forward. And we'll certainly be reaching out to you. The other stakeholders, other regulators who were unable to make the panel today, but whom we have already reached out to. And so you may be seeing the Commission then in partnership with them on these matters in other forums. I should probably also just end off by saying that there is obviously the possibility to lodge complaints at the Competition Commission if the matter that parties are faced with, be it service providers or residents, or any other firm that is facing a competition challenge. And so you can lodge a complaint. Details are on our website. There is a form you can complete. There's also a cell phone SMS number where you can send a request for someone to contact you to lodge a complaint. So I think on that note, once again, thank you very much. This is, as I said, just the beginning of this project, and we hope to see reforms very soon as we continue to work together. On that note, the workshop is adjourned. Thank you very much for your time. Goodbye.
Thank you.
Thank you so much.
Thank you.